what does it take to become a good briefing counsel? Yeah. So the first one is, see, style and all are important, fine. But if you do not have the ability, and when I say ability, if you do not have the content, if the content is not good enough, then you don't have much to talk about. I had talked about information versus knowledge. But just having information does not help. You need to have knowledge. So information versus knowledge, I gave an example. Like if you talk to a senior advocate and you're having an interaction, a conversation, and if you say, talk about, oh, this many percentage of people, this will demonstrate you have a lot of information. But when you have a conversation with senior advocates, it's important to show in-depth knowledge as well. Now we're looking at, just to take you a step higher, you also need to have an understanding when you're briefing a senior advocate. It won't suffice if you just know stuff, right? So when I say understanding, it means a kind of a holistic understanding. It means you have the wisdom as well, right? It means you have not just, you just don't know the legal position. You also know the nitty-gritties, the repercussions, why you are seeking the relief, all of that. You know the whole picture. That's the kind of understanding you will need when you are briefing. So when you're drafting, it's interesting. When you're drafting, still you need that kind of understanding, but that does not cease to have an impact there. You need to remember it. But sometimes it happens. Sometimes we draft and we forget about it. By the time it comes for briefing, we only remember what is written in the petition. We forget the kind of understanding we have developed. And that's why when we talk about the drafting process, the reason why we need to conceptualize even before we start draft is very, very important. Right. The Supreme Court has limited powers in matters before it, whether they're writs, SLPs, or even statutory appeals. You really need to understand what these powers would be when you are seeking relief, why you are seeking a certain relief. For example, in SLP, the petition would just say, the prayer would just say to grant special leave to appeal, right? There's no other relief. I mean, or any other order, etc., etc. But you are not, so you don't mention anything there except this. This is the standard prayer. This is how it's drafted. But when you can ask the court for a lot many things, and that's for the briefing counsel. So the briefing counsel may carve out something new, something innovative for the senior advocate to argue before the court, right? You cannot argue the way you would in a trial court, appellate court, or high court. So that's again something that's different when it comes to Supreme Court, since the powers. It's very interesting. Powers are limited, yet they are unlimited because you have 142. So how do you use 142 then, right? So even though the Supreme Court is looking only at question of law, where to use 142? How to use 140, all that. So it's completely different from any other court, right? Even the Supreme Court rules are different from regular trial court rules. So even when we are talking about original suit, so even if it's a suit, it's way different when it comes to Supreme Court. CPC is not binding, even when it's a suit, right? If you do not prepare accordingly, your briefing will suffer. So you really need to know. You just don't need to know what the case is about. You also need to know what the practice and procedure of the Supreme Court is. And then you need to know that what actually works and what does not. So that you are in a better capacity to assist the senior advocate, right? Further, if your drafting is incorrect or you do not raise the right arguments or invoke the wrong jurisdiction of the court, the senior will not take a matter, fearing loss to their own credibility. Suppose you were supposed to say you're coming after a long delay and you can't explain what caused that delay. Or suppose you have filed a writ petition when there is an impugned order, there is a high court order on the same issue. Now you cannot explain why you filed a writ petition, why didn't you challenge the high court order? right? You come to the senior very confidently and you tell him, oh, I was not a party there and therefore I didn't challenge it. The senior would ask you, so what? You could have moved an IA, you could have moved an IA seeking permission to file an SLP. It's as simple as that. You didn't do it, nothing. Right? So all the knowledge of law that you have doesn't work because you didn't know this much, right? It's this much. It's very simple. It's very basic when it comes to Supreme Court practice. But that's one side of it. The other side of it, only if you know this much, rest you already know because you have been handling way more difficult stuff down there. The legal position remains the same. You are using the same Supreme Court judgments and your courtrooms. You're handling the matter for such a long time. So you know those stuff. You just need to know this, right? The case is 99 to 100% prepared by the briefing counsel, right? So senior counsel has a huge role to play, and I'm not taking that off from them. They can be a case winner. They can do miracles with the case even when they are not briefed properly, or even when they have been briefed properly, they add their own style to it. And then the briefing counsel also recognizes that, yes, if I would have argued, I would have done such a good job. He gave this twist, or he had that presence of mind when the judge was asking this question. But still, preparatory work is done by you, and that is to be done by you. The senior counsel will not guide you or perform additional research. There are juniors to assist him, but again, then unlike our chamber, we have many juniors in our chamber. But otherwise, there are not many juniors. Even if one or maximum two are also assigned on a matter, still they only have that night in between, and they may have other matters next day, and therefore it's you who's primarily responsible. They may do it. They may still do it. Like I do it. That the people, the briefing counsels who prefer to have me on the matter because I add things that they may not have found, right? Uh, I, I mean, yeah. So that happens. There have been matters that have been referred to me just because of that. All that happens, but still, you that's kind of a support you can look for, and you may have that kind of coordination with a senior's office, but still primarily it's you who are going to work on it. Right, so this I have already told you. Right, quality will be influenced. Senior advocates are some of the smartest lawyers, and clients will observe you in briefing meetings. If they see the seniors shouting at you, they'll infer they have not done your job. So that's another thing you need to keep in mind. Therefore, you need to be very well prepared because you have a client with you who is reposing confidence. On the other hand, if you brief effectively, the client will trust you more than they trust you. Trust me, that's what happens because they realize how much work you've put in. You think the client doesn't understand, he understands everything. So the other thing that you need to keep in mind is to send the brief as soon as it is filed. Two advantages. Uh, One, juniors get time to research. You don't know how much work the junior would be capable of putting in. It may only help you. The junior will mark, flag the relevant pages beforehand. Some people even send us the note beforehand. It only helps, right? The other point that I was telling you, the other side cannot then engage the senior once he has accepted it from you. Uh, you coordinate with the assigned junior, etc. Yeah, so as I was telling you before as well, that you take the senior through the file in the shortest possible time. So if it's an SLP, if it's an appeal, there will be an impugned order, and you will then take him through. So you'll just like Abhyuday was reading the order. So you will point out the important points there. You'll already mark it in your file, and you'll just take him through those pages so that nothing is missed out.
I'll
Right.
give you one example that in college when you're studying Contract Act, what do you see? You read the Bare Act. If you are studying a case, then you're studying the case law, right? Now your impugned order work at the Supreme Court is like that you are going to study one order, but from the perspective of challenging it in a way that a Supreme Court lawyer would. Okay, so there's a specific filter and a specific lens you have to look at it from. Okay. So that's that. And Kumari Shelley, you are saying private lawyers won't get original jurisdiction work. Yes, you will get writ matters, but you will not get original work between state versus state disputes or center versus state disputes, is what I said, because those would be taken by like panel counsel or standing counsel or advocate general. Is that correct, Sanchita?
Yes, yes. But original jurisdiction writ is also part of original
Writ
jurisdiction.
will
Just
you will get as a private lawyer.
yeah, right. So yeah. So after a good briefing, a senior would be able to recall the facts, may have to refer to the note for the exact dates, but you have taken him, remembers all the arguments one after the other, and has the paragraphs marked in his own file so that when he's referring to it during the arguments, he does not have any inconvenience, right? So you cannot do it at that time when the arguments are going on. You cannot point out everything at that time, and therefore you would want the senior to mark it in his own a good briefing counsel gives a holistic picture, points out all the dimensions of arguments and counter arguments. You're preparing the senior advocate. So even if it does not strike him, you need to tell him that the other side can say this. Then you make him to think how he'll answer it, or you suggest something. That's how you prepare. You're actually preparing. So you're instructing and you're also helping him prepare for the matter. So that's what we also do as juniors. In the morning when we go, we become the devil's advocate, and we tell him, but what about this? What about that? And then he thinks, he answers. It's like a brainstorming session that you get to do. That's part of exercise. Points out any doubt. So that's another. So this is also the time when you also point out that you think that this point argument may not work for XYZ reason, and then you give an opportunity for the senior to devise a strategy on how he would want to make it work, right? Right. So you also, as Abhyuday was pointing out, you need to do thorough research on your on judgments. The senior does not have time. The senior won't do it, first of all, and secondly, he does not have time. Don't overestimate the knowledge. As somebody said, he will know everything. So he definitely doesn't know the facts of your case, and you just need to assume that he wouldn't know unless he realize or he knows this. Then that's different. But otherwise, you just take him through everything, and it's not a bad thing. Don't underestimate intelligence. Don't overestimate. Don't underestimate it. So, explain why you think the senior needs to emphasize more on a certain point than on another. So just saying that this is what I want you to argue, this is the most important point, you are also explaining him why he needs to do. That's something that's important for me. If you don't explain me why I need to do something, I may not do it. So that's important that you explain it to the senior as well. Explain it even if the senior doesn't ask. Yeah, so that he knows and he follows that path, he knows why he's doing it. It gives more clarity, it would show up in arguments. Yeah, so even if the judge asks him a question, he'll have the holistic picture. So you just having it in your head does not help. You thinking that if the judge asks, I'll murmur in his ears, doesn't help. You need to tell him beforehand. Because unlike other courts, it's not two people speaking, only the arguing counsel speaking. You are telling him something in his ear. He may not be able to hear properly because he's also listening to the judge. He also is thinking what he has to say, and then you are constantly poking him. Doesn't work, right?
Also, I think one of the best opportunities for a lawyer to get some face time, I mean, some time before the judges at the Supreme Court, is when the senior is not there, for some reason couldn't attend the hearing, and you get the opportunity. So because you briefed so well and you are fully up to date with the matter, you can actually argue, and judges encourage that. They will be like, okay, your senior is not there, can you argue, please? Okay, sometimes they'll force you to argue. They will say that no, you must argue because otherwise this case gets very delayed. So
Yeah, yeah. Sometimes you are not being given a passover. The case is being adjourned. Then you have to take a call for your client that if the case is adjourned for another 3 months, 6 months, what will happen? It may turn infructuous. So then what do? You argue it. So good briefing counsel will choose to argue the matter himself herself, get the relief. Right? Or the senior may be busy in another court and there's no other option but to argue. The senior has to leave, etc. There can be so many kind of circumstances when you may.
either you're good at getting non-verbal language, or it's better to anticipate every possible situation the senior may have in mind and address them, whether or not he asks you. As a prudent measure, identify, imagine all the possible scenarios, Address them. Okay. Some lawyers conclude the briefing with a short summary of the arguments. That helps the senior in revisiting what the crux was. Okay. And end it by saying, okay, if you can just say this. Does this help, Sanchita? If you can just say dot dot
Yeah.
dot.
So as I was giving example of Mr. Vijay Agarwal. So you start. Let's first talk about the body language. So even if the senior is not saying anything and he's letting you present your case the way you want to, you make it clear at every point. That's number one. Number two is that you when you end it, to again summarize it. It helps to remember. So you summarize all your arguments, and then, like Mr. Vijay Agarwal would do, you can end it by saying, if you just say this, you just simplify it to this extent that the senior is very clear that this is what will sail me through. This case is simple. If it's simple for him, it will make it simple for the judge as well. Right. Yeah.
This is a very
Should
important point. Huh? Don't shy
yeah.
away from saying exactly what you want the senior to say. Just makes life simple. It's not like you're instructing, like you're not ordering the senior. You're giving them, you're helping them out.
Seniors, and in fact you're instructing. So seniors, if they get stuck at some point, they'll say, oh, my instructions are this. So whatever the briefing counsels tell him, he says my instructions are this. So you're actually instructing. You need to be very clear that you are giving him instructions, and therefore there's no hierarchy there, that, oh, whatever the senior will say, etc. You're giving him instructions on behalf of it. Seniors are way more receptive than any of us. That's true, but some are not. Okay, some like to complete a sentences and make it seem the point you're making is very trivial. That also happens, but you can just be with it and continue to brief him. But mostly they're receptive and allow you to express yourself. But gradually you can notice them forming opinions as to how strong the case is. Therefore, you should be in your game and you should continue to do what you have come there for. Like when we were briefing Mr. Rohadgi, I mean, I should tell you, it was the same kind of experience. Like when he argues in court, he's very, very aggressive and he's very clear as to what he's trying to say, etc. So when we were briefing him, he was again very clear that this does not make sense and stuff. So we still had to stick to our point and say, oh, this is why we have written this and this is why we want to do this, etc. Right? So this can be a challenge you may face at some point. If the senior has a doubt in mind, you have to try as hard as you can to change it. Because as I was telling you, with the help of that story, if that doubt stays, he'll not be able to remove that doubt from the mind of the judge. Okay. It can be done with conviction, right? You can instill confidence if you are a confident briefing counsel, right? You should not feel intimidated as a bit
Because
of
the senior may be, getting anxious or shouting or, demanding things. So don't react to that body language, but you should react to the language where they are, you should follow whether they are able to follow you and all of that. Okay. So
right.
that is very important.
I think we can proceed. So yeah, I think these all we have covered.
Yeah.
Right. Yeah, so a judge of a Supreme Court also decides based on equity. So you need to understand the context of your client's life as well and put it across to the briefing counsel. Like to the senior counsel, one of the briefing counsels also tells us that, oh, this guy is not getting married because this case is not getting resolved. So you go to that extent to get the senior counsel on your side. Good briefing counsels don't just keep the legal points before the senior, but also narrate the context, like the hardship the client is going through, etc. Generally, even in court, marriage is something I just said. Generally, it helps even when he's arguing before the court to put the equitable grounds across. Right. Okay.
All narrative is priority, I think, is top priority, and all law has to be framed into the context of the narrative. Without the narrative, the law becomes very, very tiring for a judge to listen to. Okay. So even
Right.
for a senior counsel.